Hello and welcome to the latest in our food law video series. And today I'm joined by Katrina Anderson from the UK office and Gail Saint-Jean from the Paris office. We thought it would be really helpful to give you a little bit of an update in relation to CBD, because quite a lot has actually been happening on the CBD front. Now, it was last year that in the UK, the Food Standards Agency came out as a result of the European Commission placing CBD on the novel foods catalogue and said that all the CBD product that currently exists on the UK market would have to have at least started the novel food process and have a validated application. And it's only those products that have got that validated application that will be able to remain on the market post the 31st of March 2021. So there's quite a lot happening for CBD manufacturers in the UK. But Gail, just turning to you, I mean, the position in relation to CBD has been quite different in France. You don't have this plethora of products on the market over there.
No, that's true. Actually, there are some operators on the market, not only for food products, but also for electronic cigarettes, or more generally what we call the well-being CBD products. And it's true that the situation from a legal point of view is very complicated. Because in a nutshell, we have kind of prohibitions today in France. Since we have a French decree limiting the authorization to import and to market varieties of cannabis sativa L to the sole fibers and seeds. And since CBD is usually not extracted from fibers and seeds, then this leads to a de facto prohibition to import and commercialize CBD products in France. And so just from a strict legal point of view, the situation is that the debate so far has taken place in the field of the legislation on poisonous substances or even drug trafficking, which carries, of course, heavy criminal penalties.
Yes, indeed. So that's really interesting. So actually, the French decree has said that it's only product coming, or cannabis product coming from fibers and seeds, that will be permitted on the market. And because you can't take CBD from fibers and seeds, you don't therefore have CBD on the market in France. Katrina, very different situation to what we have in the UK. I mean, why have we got this discrepancy between EU member states?
I think partly because all of this has an association with drugs, and therefore member states do take quite different views on these things. But also the situation was always probably unclear, but a sort of series of decisions at an EU level have really sort of served, if you like, to either clarify things or confuse things, depending on your perspective. But it started really with the EU updating the novel foods catalogue to say that CBD was, in most situations, a novel food and therefore required authorization. And on the back of that, obviously, companies that wanted to sell CBD started putting together applications. It became apparent last summer that some of those applications were being rejected at the validation stage because the EU was saying, well, actually, maybe these products are actually drugs or narcotics under EU law, and therefore are not eligible for an authorization under the novel foods regime because they're not a food. And that's why the French position suddenly became very, very important, because there was this referral from a French court which touched on the question of whether or not CBD was in all instances a narcotic or a drug under EU law. So suddenly there was a lot of interest in this case.
Well, that's great, and let's look at the details of the case, Gail. I mean, this is the Canna-Vape case that that took place in France. Can you just explain a little bit more about the background to the case? So, what are the facts of the case that led to the ECJ referral?
Well, the case started with a shop, a small shop in France, selling electronic cigarettes containing CBD oil. And there was a criminal prosecution starting against this shop. And if I remember correctly, in the first instance, there was a sentence. So he was criminally sentenced. And then there was an appeal. And the Court of Appeal considered that it was necessary to get the interpretation of the ECG as regards the EU law to understand if indeed the French decree could be considered as non-compliant with the EU law. And what is interesting also to note is that actually in France, we already had several decisions considering that we had an issue of compliance with EU law with this French decree. So technically, there was already some discharge decision in France. But now the ECG decision will give obviously more power and more weight to this argumentation of the non-compliance of the French decree.
So specifically, I mean, in terms of what the ECJ actually said about the French decree, what was their conclusion as to how the French decree aligned with EU law?
The main point of the decision regarding the French decree, we can explain in two phases, because the compliance of the French decree has been analyzed as regards the principle of free movement of goods. And then there were two parts in the argumentation. First part, we need to first analyze whether the CBD at issue in the present case could be considered as a narcotic drug, because if it is, obviously, we don't even need to look at the free movement of goods. And to this first question, the ECG answered that no, in the present case, the CBD cannot be considered as a narcotic drug. And then they could look at the compliance with the principle of free movement of goods. And even if, of course, I would say the final analysis will have to be done by the French courts, the ECG gave some very useful guidance to analyze this compliance by noting that, first of all, the French prohibition could not be applied to synthetic CBD, which indicate that probably the French decree should not be considered as an appropriate measure. And second, that such measure that is obviously a measure having equivalent effect to quantitative restriction on imports, if it must be justified, it can only be justified when based on a real risk to public health, which cannot be based on purely hypothetical considerations. And we understand from the ECG that obviously the French government was not able to provide clear data on this not purely hypothetical risk as regards public health. So at the end of the day, the ECG took the position that obviously the French decree should not be considered as either justified or proportionate to as regards the objective to protect public health in this case.
Okay, so there's a number of interesting points that come out of that, really, Gail. And I mean, I think it's important to stress, of course, that this wasn't CBD in a food product. This was CBD, in an oil that was being used for vaping. But still some really interesting points. So recognizing that the free movement of goods, or that the French decree conflicted with the free movement of goods point. So potentially that French decree is now going to fall away, we assume.
Which,
I mean, of course, opens up the market for CBD in France. But of course, it then brings into this debate whether, in the same way as in the UK, is the CBD a food or is it a narcotic? And I think there's some quite interesting points there about the actual product and and where the parts of the plant that were being used in that particular case, and whether we can draw a few conclusions on that. And Katrina, maybe just turning to you on that. I mean, can we say, based on that French case, that actually there are that certain CBDs, depending on how they're formulated, what parts of the plant they're collected from, may therefore fall outside of being classed as a drug and may fall more into the novel food arena? Or I don't know, you tell me, what kind of conclusions do you think we can draw?
We can definitely draw the conclusion from the case that it is possible to have CBD that is not considered a drug or a narcotic under EU law, because the court concluded that the CBD at issue was outside of that definition. The court was quite influenced by a World Health Organization report on the health effects of CBD and the fact that there was no evidence that this CBD had any kind of psychotropic effect. But they were also very influenced by the fact that the CBD at issue came from the entire plant. And this is significant because the definition of a drug or narcotic in EU law is based on the UN Single Convention. And the Single Convention defines cannabis as being from the fruits or flowering tops. And that includes extracts, which of CBD would be a type. So the question came to the court whether a product which is made partially from the fruits and flowering top, but also from other parts of the plant, could fall outside of the Single Convention. And the court said yes. But what we don't really know is anything about the details of that product. So what we don't really know is how much of a product would have to come from parts of the plant other than the fruit and flowering tops to fall into that definition of not a drug. And the only way to be a food would be effectively to be not a drug. So that is, it means that in principle a novel food application can be validated on that basis, but we don't have a lot of guidance at the moment as to where the lines are.
So basically, if your CBD is coming purely from the flowering tops or the fruits, then it's definitely falling under the narcotics list, so it's under the Single Convention. But actually, once you've got CBD that's coming from other parts of the plant, from the leaves, from the fibers, from the seeds, then potentially you have an argument that it could fall under the food regime. But we're not clear as to how much and what proportion of those parts of the plants would need to be into it. Okay.
And I think the court hasn't even said that a product exclusively from fruits and flowering tops would be a problem, but it's hard to reconcile that with the drafting of the Single Convention. So I think it would definitely be a quite a threshold to climb to prove that you are not a drug or a narcotic.
And then when we move into the Single Convention, and this is obviously coming from the UN and the Commission for Narcotic Drugs, and they had an opportunity recently to be able to vote on some amendments to the Single Convention, and this is important because, as you say, our EU law is based on the UN Single Convention, so changes to the UN Single Convention should translate into changes in EU law as well. But what were the two amendments, Katrina, that they were voting on, and what was the result?
So there were high hopes in the sort of CBD industry that there would be significant changes legally as a result of these votes, and that those proposals that the CBD industry were particularly interested in focused on, first of all, a footnote which would actually specifically say that CBD fell outside of international control on drugs. So effectively, it was not a drug. And the second was deleting the words extracts and tinctures of as a sort of concept from cannabis, because that would suggest that potentially extracts like CBD weren't caught. Unfortunately, neither of those proposals passed, and the first one actually was very, very comprehensively voted down. Very few countries voted in favour of that. So actually, to a large extent, that vote, which had raised a lot of hopes in the industry to sort of change the legal position, probably has had relatively little change to the position we've just spoken about, that actually we fall back largely on the CanaVape case. I think the only thing that one can take away from that is that there isn't a lot of appetite internationally to make a very positive statement that CBD is not a drug.
Okay, so basically we think we're now in a place where France, once the decree has gone, is in a similar place to the UK. There are certain categories of CBD that would far more clearly fall under the convention for the single convention for narcotic drugs, but actually for other CBD coming from more of the plant, not just the flowering tops of the cannabis plant, then they are likely to still go through the novel food application process, and they still have to go through that process, but it's following the food route rather than following or being banned by virtue of falling under the drugs regime. Is that where we're at, ladies?
I think so.
I think so too.
Until our
Fantastic.
next video.
Quite right, Katrina. So until our next video, when we'll give you the next update in relation to CBD, I hope you've enjoyed listening to us. And thank you very much, Katrina and Gail, for joining me today. And we'll see you next time. Bye-bye.
Bye.
Bye.